Hey, what's up everybody? This is Mike Riley, and in today's video, I'm gonna talk about the process of selecting a jury in criminal court. Criminal jury trials form the bedrock of the American criminal justice system, and understanding the process by which lawyers select a jury is fundamental to your understanding of the law. In today's video, you can expect to learn about the function of the jury in the American criminal justice system, what lawyers are looking for when they're selecting a jury, and how potential jurors are eliminated from jury service. Let's get started. Now let's talk about the function of the jury. The main function of the jury is to hear the evidence and return a verdict that's based on the evidence. So when we're selecting a jury, we're looking for people that can be fair and impartial to both sides. We're looking for people that can follow a judge's order about the law. We're looking for people that are not going to be distracted and go doing their own homework or own research about a case. The jury sits there, they listen to all the evidence that's presented, they listen to all the instructions of law given to the jury by the judge, and then they start a process of deliberation where a jury goes into a deliberation room, they talk about what they heard in court, and they try and come to a verdict. They try and reach a decision about what the verdict should be in a particular case. Now, another function of the jury that's talked about less often is their duty to determine the credibility of the witnesses that testify in court. Not everybody who takes an oath to tell the truth in court tells the truth, and it's up to a jury to decide who they believe, who they don't believe. They might hear a witness and say, you know what? I believe every word of what that person said. They might hear a witness and say, some of what they said I believed, some of it I don't. And there will be witnesses who come to court and a jury's gonna say, you know what? I can't believe a word of what that person said. And that's a lot of what lawyers are doing at trial. They're impeaching witnesses, trying to undermine their credibility and suggest that you cannot believe this person, or in the alternative, bolstering a witness's testimony, trying to show things that corroborate it to suggest that this is a person whose testimony you can rely on. It's up to no one but the jury to decide who is telling the truth and who's not. It's not up to a judge, it's not up to a prosecutor, and it's not up to the defense attorney. Now, jury selection is important to lawyers for a few reasons. First, it gives them an opportunity to find jurors that can be fair and impartial. It also gives lawyers an opportunity to get to know the potential jurors, who they are, where they're from, what they're doing in their life, and lawyers are going to try and get as much information as possible, so it allows them to determine if this juror is likely to go their way or is likely to go the other way. Lastly, jury selection is important to lawyers because it gives us an opportunity to preview our case. Now, you can't get into the facts of a case in jury selection, but you can ask jurors questions that start to float your theory of the case. For example, I've done several self-defense cases. Now, in a self-defense case, I'm not allowed to preview the evidence to a juror, but I can ask them if they could follow an instruction on the law about self-defense. And that would look something like this. Hey, Mr. Juror, at the end of this case, I anticipate that the judge is going to give the jury an instruction on self-defense and is going to explain that there are certain circumstances where a person is justified in using force, even deadly force, to fend off an attacker. If the judge gave you that kind of instruction, do you think you could follow it? Now, I'm not talking about the facts of the case, but I'm entitled to ask that question because some jurors might say, I don't believe in self-defense. There's never an excuse to use force against another person. Even if a judge gives that instruction, I'm not going to follow it. I have every right to explore that issue, but by doing it, I'm also starting to plant seeds in the minds of the jury about what my case is about, what my theory of the case is, and get the defense started right at the beginning, right at jury selection. It is often said that cases are won and lost during jury selection. I think it's a crucial part of a trial. I think it's incumbent on defense attorneys to take the time to ask potential jurors all the relevant questions to get to know these people and make smart, informed decisions about who you place on the jury, because that's going to make a huge difference in the outcome of the trial. Now, the process of jury selection is, in a sense, a process of elimination. Jurors are brought in and they're eliminated from service, and the ones that are not eliminated end up on the jury. So there's two different ways that jurors are eliminated from jury service. dangerous. The first is they're eliminated for cause, and the second is they're eliminated by what's called peremptory challenges. So first, let's talk about what a challenge for cause looks like. A challenge for cause is based on an answer that a juror gives that suggests that they could not be fair, impartial on a particular case. Now, there's no limit on the amounts of challenge for cause that a lawyer can make. You could challenge every single juror for cause if you want. It's certainly a good way to irritate a judge, and you shouldn't do it unless you have a real argument, because you're wasting everybody's time and ticking off a judge, which is never a good idea. But if a juror answers a question in a way that suggests that they can't be fair and impartial, a challenge for cause is appropriate. I've picked my fair share of juries over the years, and I've eliminated jurors for cause for a variety of reasons. However, there are 3 questions in particular that I eliminate more jurors for cause than any others. The first has to do with police officers. I ask every potential juror about their feelings about police officers. I then follow up and say, do you think a police officer is any more likely or less likely to tell the truth on the witness stand than any other witness? Now, most jurors will say, I don't think they're any more likely or less likely to tell the truth. I'm going to listen to the judge's instruction, and I'm going to treat a police officer the same way I would any other witness. I'm going to weigh their credibility the same way I would any other witness and make my own determinations. Other people come up and say, listen, I'm a big supporter of law enforcement. I support the work they do, and I think that police officers are more likely to tell the truth than anybody else. Now, if I follow up and say, well, if the judge tells you that you're to treat police officers the same way you treat any other witness, they don't get any particular advantage or disadvantage by virtue of the fact that they work as a police officer, could you follow that instruction? And if a juror says, nope, I can't, in my mind, police officers are more likely to tell the truth, that juror can be eliminated for cause. The flip side of that is if a juror comes up and says, I don't trust cops, I think cops lie, then they're asked the same question. If the judge gives you an instruction that you're to treat a police officer's testimony, evaluate it the same way as any other witness, could you follow that instruction? If the person says, you know what, yes, I could follow that instruction, a challenge for cause is not appropriate. But if, like the previous example, they say, no, I'm going to disregard the judge's instruction and follow my gut, that person could be eliminated for cause. The next way that I frequently get people eliminated for cause is a question about the defendant's arrest. You don't end up in criminal court without an arrest. It's how the process starts. So I will ask a potential juror and say, listen, my client was arrested. We wouldn't be here if he or she was not arrested. Does the fact that he was arrested make you think that he's probably guilty of something? Now, the correct answer here is no. I heard the judge instruct me this morning that the defendant is presumed innocent, that the fact that he or she was arrested is not evidence, it's not something I'm to consider, and I'm to give this person the presumption of innocence and make no assumptions, come to no conclusions. That's the right answer. But a lot of jurors, they'll answer candidly and say, yeah, I think if he was arrested, he's probably guilty of something. There must be some reason. And again, we follow up. If the judge gives you an instruction that you can't consider it, can you follow that instruction? Those that can follow the instruction will be kept on the jury. Those that can't follow the instruction will be eliminated. Another line of questioning that gets a lot of jurors eliminated for cause has to do with the defendant's option to testify. The defendant can never be compelled to testify in criminal court. The defendant in a criminal trial has a Fifth Amendment privilege to remain silent. They do not have to testify. Every single juror I come across, I ask about this. My client has a right not to testify. He's charged with murder. How would you feel if you didn't get to hear from him in this case? Now, the correct answer is I heard the judge's instruction. I'm not to draw any negative inference from the defendant's decision not to testify, and I can certainly follow that instruction. Other people will say, I don't know, that's going to bother me. If he's not guilty, I need to hear him get up there. And if he doesn't, I'm going to hold it against him in some way. And if a juror answers that way, they could be eliminated for cause. And one more topic where our jurors get eliminated for cause involves the bloodier, the nastier cases that have perhaps autopsy photos, crime scene photos, things that are difficult to look at. I will ask jurors, hey, this case involves autopsy photos, pictures of dead bodies, pictures of crime scene. Can you look at that stuff? We don't have people lining up outside the courthouse, volunteering to be jurors on these really difficult, gruesome cases. Nobody wants to look at this stuff. Defense lawyers don't want to look at this stuff, but it's part of the job. We need to make sure that we find jurors that are capable of considering all the evidence, and they're going to be able to look at things that are difficult, study these exhibits, and return a verdict that's based on the evidence. And occasionally I get a juror who says, nope, not for me. I can't look at that stuff. I'll get sick. And those jurors usually can be eliminated for cause because they're essentially telling us that they can't return a verdict based on the evidence because they can't consider the evidence. It's overwhelming for them. It's too much. And like I said earlier, there are other reasons that a juror could be eliminated for cause. Those are just the examples of the questions I see jurors get eliminated for cause on more often than others. The other way that lawyers can eliminate potential jurors from jury service is by exercising what is called a peremptory challenge. Now, this is different from a challenge for cause. A peremptory challenge is basically a freebie. With a peremptory challenge, lawyers can eliminate jurors for almost any reason, provided it's not a specific reason that's prohibited by law. So at the beginning of jury selection, lawyers are generally given a set amount of peremptory challenges, and they get to use them to eliminate people that they don't want on the jury, but that answer the questions correctly and can't be eliminated for cause. It's always a better idea to try and eliminate somebody for cause because you don't have to essentially burn a peremptory challenge. Now, an example of somebody who I might want to use a peremptory challenge on is somebody that answers all the questions correctly, but I can tell that they're struggling with a particular issue of law. So let's go back to my example of asking jurors how they would feel if my client didn't testify. So let's say I ask a potential juror, my client has a right not to testify. How would you feel if they didn't testify? And if the juror says, oof, I don't know how I'm going to feel about that. I guess I could be fair to them. Yeah, I guess I could be fair to them. Okay, so they answered the question correctly. They're indicating that they could follow the judge's instructions about the law, but I saw them hesitate. So some part of them is balking at that question. Now, they answered it correctly. They could be rehabilitated. A prosecutor could get up and say, listen, if the judge tells you you can't hold it against the defendant, can you follow that instruction? Yes, I could follow that instruction. Great. They can't be eliminated for cause. But you can bet I'm going to use a peremptory challenge to eliminate that juror because I saw them hesitate. That worries me. I don't want anyone on the jury who's going to potentially hold something against my client. Another time I'll use a peremptory challenge if somebody's affect is just off. If somebody comes in and it seems like they have a problem with me or they have a problem with my client, they won't look at my client. Really, if I catch a vibe, right? If I catch a vibe from somebody that this is not going to be a good juror on my case, I very well might use a peremptory challenge to eliminate them. Now, there are limits on when lawyers can use a peremptory challenge. Lawyers cannot use peremptory challenges to eliminate jurors on the basis of race, gender identity. I mean, there's a number of categories depending on which state you're in. Now, if I'm picking a jury on a criminal case and the prosecutor, let's say, is eliminating every African-American person who comes up as a potential juror, I can challenge that behavior. It's called a Batson challenge. I could stand up and say, whoa, they're eliminating all these people in a particular category. It's inappropriate. This prosecutor is misusing his or her peremptory challenges. The burden then shifts to the prosecutor, who would have to give some neutral reasons why they were eliminating these people. If they can't, they're not going to be allowed to eliminate that juror, and that juror could potentially be seated as a juror at a given trial. One of the questions I get asked more often than almost any other question as a defense lawyer is people say, hey, Mike, how do I get out of jury service? And this is kind of a bummer, right? It's your civic duty. We need jurors. I suppose I did answer it in this video, especially on the discussion of challenges for cause. If somebody says they can't be fair, they can't be impartial, that they're not going to be able to follow a judge's instruction on the law, that person can be eliminated for cause. And quite frankly, I don't want jurors on my case that don't want to be there. It's very obvious when somebody comes up and they want nothing to do with the case, they want nothing to do with jury service. You can tell when someone is trying to get themselves disqualified, and oftentimes the prosecutor and the defense attorney will agree, let's just get rid of this person. Like, this person's wasting our time. We don't want somebody who doesn't want to be there. We don't want someone who can't focus on the evidence, be fair to both sides, and return a verdict that's based on the evidence presented at trial. So what do you think? Would you like to serve as a juror on a criminal case? Do you think you could look at these difficult exhibits and remain objective? Do you think police officers are more likely to tell the truth than any other witness? Should a jury be able to consider a defendant's election not to testify when returning a verdict? I would love to hear your thoughts and comments. Stay tuned for more videos, and thank you so much for watching.